prior position of the Justice Department, the prior position of the archives, the kind of key case on this here in the District of Columbia, other cases, and the Constitution gave great deference to a president's decision to keep records personal versus presidential. And the presumption was if he had them after he left office, there was no second guessing. And, you know, we've talked about this Clinton sock drawer case that Judicial Watch had pursued almost well over a decade ago. I think we filed it first in, when did we file it? 2010. We filed it in 2010, and then the big decision on it came in 2012. So it was like, you know, it was 2 years of litigation. And the Justice Department, forget about the decision, which essentially said that it's difficult to challenge a president in terms of his decision-making versus as to what he wants to keep as personal records versus presidential records. You know, that decision is important, is well worth reviewing, and I've talked about it before here. But secondly, and arguably more importantly, it was the Justice Department's position. It was the National Archives' position, and they changed their position as to the deference and prerogatives of a president, specifically for Donald Trump, which further highlights the corruption behind the targeting and the indictment. And of course, then there's the equal application of the law. You know, we all have a right to full protection of the law under the Constitution, and you know, we can't be denied equal protection of the laws. And it looks like that's what's happening to President Trump. You've had similar corrupt, well, frankly, Trump didn't do anything wrong, but you've had significant evidence of criminal activity by Hillary Clinton with respect to records that Judicial Watch uncovered. I mean, so we know full well what Hillary did. She took documents she had no right to under any law, FOIA or the Federal Records Law, for instance, or laws against the mishandling or taking of classified information. She deleted material after it was subpoenaed, her people did, and including classified records. And she lied about what was on that deleted material because Judicial Watch uncovered there was classified records on that deleted material. She was, the documents showed she was involved in also turning the State Department into a play-to-play organization for her political operation at the Clinton Foundation. You know, something else that she lied about as to what she was doing. And of course, you know, Bill was taking all this big money and speaking fees from foreign governments while his wife was Secretary of State. So you had all this evidence of criminality, specifically though with respect to records. Nothing's been done. Now, Joe Biden has been implicated in literally one-for-one similar activity. Having records he had no right to under the Justice Department's theory of the law from his days as vice president, scattered across the East Coast. From here in Washington, D.C., all the way up to Delaware. Remember the documents in his garage up in Delaware? And includes documents from his days as a senator. So there's no doubt, at least classified records from his days as a senator, no doubt he had no right to those records. And yet he is no raids, no significant grand jury activity. The so-called special counsel that's looking at that is nowhere to be found. So this disparate treatment is rather obvious. And of course, then there's this prosecutorial abuse. We've had allegations that the co-defendant of President Trump, his body man as it's called, is a good man, Walter, his lawyer was essentially, this is what happened, or the allegation is, they're in a discussion with the top DOJ official about these issues. And his lawyer evidently had signed up to be appointed to a superior court judgeship here in the District of Columbia, which is, and you know, local judges for one of, you know, they're kind of the equivalent of state judges here in the District of Columbia are appointed by the president, and there's a process from which that's done. And he had put his name in the hat. And the Justice Department attorney suggested he'd have a better chance of getting appointed if they cooperated with him. I mean, it's wildly abusive and frankly illegal if that took place. outrageous prosecutorial abuse. And as I've said, I saw it firsthand with my grand jury appearance where the Justice Department prosecutor tried to get me to swear under oath I wouldn't talk about what happened in the grand jury, even though I had every right to do so. And he tried to fool me into swearing under oath. And thankfully, I kind of pushed back a little bit and refused to do so. So more prosecutorial abuse. And of course, there was no good faith basis from the get-go to go after these records based on the Presidential Records Act, because, as I said, the prior position of the Justice Department, the prior position of the archives, the kind of key case on this here in the District of Columbia, other cases, and the Constitution gave great deference to a president's decision to keep records personal versus presidential. And the presumption was if he had them after he left office, there was no second guessing. Same goes for, in my view, the issue of national defense information. As Commander-in-Chief, of course he can authorize himself to keep defense information under the law. Indeed, the indictment talks about him putting records, whether they be classified or personal, whatever. He put these records into the boxes that had his personal effects. So they describe him making these records personal, whether they be covered by the national defense information, under the Espionage Act, or the Presidential Records Act. Either way, no matter how you slice it, Trump did nothing wrong. Trump did nothing wrong. Now, this Clinton sock drawer case is making the left very nervous. And it's the Justice Department obviously avoided talking about it at all in its indictment, but they've been doing their best to try to downplay it. And I encourage you, if you haven't already, to review my colleague Michael Bekesha, who's a senior attorney here at Judicial Watch, who litigated and, as we laughingly often mention, we lost. We lost the Clinton sock drawer case, even though we took the current position of the Justice Department in seeking oversight over what the Presidential Records Act allowed a president to do, meaning that the Presidential Records Act should have required these sock drawer tapes that, at least according to at least one report, talked about, sending cruise missiles against al-Qaeda or bin Laden at one point. I mean, quintessential national defense information, quintessential classified information. And remember, they told us there was nothing they could do to get those records because Clinton had them and he had designated them personal simply by the act of taking them away from the White House. So Michael's piece is in the Wall Street Journal describing that, and at the end he says, by the way, if Trump, even if they proceed with this case, theory of the law on Trump, we want those Clinton tapes, right? But this is a case that can potentially exonerate the president. It's certainly his best defense. So they're trying to undermine it. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.